Welcome back, class 10, your civics class. We were revising Supreme Court. Today we'll start with Appellate Jurisdiction. A court of appeal is one which may change the decision or reduce the sentence passed by the lower court. That means, what is a court of appeal? That a court of appeal is such court which can reduce the sentence or the decision which the lower court have passed. So Supreme Court is the final court of appeal, because beyond that you cannot appeal to any other court, because it is the apex court. So an appeal lies to the Supreme Court from any judgment or final order of a high court in India. That means, suppose any high court passed a decision or passed a sentence against somebody, that person can appeal to the Supreme Court through appellate jurisdiction. So Supreme Court can change the decision which the High Court has passed, reduce the sentence which the High Court has passed, or can retain it. So the appellate jurisdiction extends in the following cases. Number 1, constitutional cases. Every High Court has the power to interpret the Constitution and to issue writs for the enforcement of fundamental rights. However, on matters involving interpretation of the Constitution, the Supreme Court has the last word to say. The High Courts may interpret the Constitution or can issue writs to enforce fundamental rights. But in the case or in the matters involving interpretation of the Constitution, understanding the Constitution, whatever the Supreme Court rules, whatever the Supreme Court says, the Supreme Court's word will be the last word. An appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies that the case involves interpretation of the Constitution. So one can appeal to the Supreme Court from any judgment of the High Court if the High Court certifies that yes, in this case it involves the interpretation of the Constitution which the Supreme Court is licensed to do. If the High Court refuses to give such a certificate, the Supreme Court may grant special leave of appeal. The Supreme Court can take the case anyhow. These are constitutional cases. Under civil cases, appeals in civil matters lie to the Supreme Court. If the High Court certifies, number 1, that the case involves a substantial question of law of general importance, and the question needs to be decided by the Supreme Court. Therefore, no bar on Supreme Court's power to grant special leave on appeal in suitable cases. These are under civil cases. Appeals in criminal matters. There are two ways in which an appeal in criminal matters may be brought before the Supreme Court. Number 1, without the certificate of High Court, and with the certificate of High Court. First, without the certificate of High Court. An appeal lies in the Supreme Court if the session judge has acquitted the accused, but the High Court on an appeal from the government reverses the decision of acquittal and sentences the accused to death, and if the High Court has withdrawn any case from a subordinate court and has convicted the accused and sentenced him to death. So, number 1, if the session court or the session judge has acquitted, freed an accused person, but the High Court on an appeal has from the government reversed the decision of the acquittal and sentenced the accused to death, it can be appealed to the Supreme Court. And if the High Court has withdrawn any case from the subordinate court, and convicted the accused and sentenced him to death, it can be appealed to the Supreme Court. These two matters are without a certificate of the High Court. And with the certificate of the High Court, an appeal lies to the Supreme Court if the High Court certifies that the case is fit for and appeal to the Supreme Court. So in these two cases, it can be appealed. Now, special leave to appeal by Supreme Court. The Constitution gives a very special kind of power to the Supreme Court. And what is it? The Supreme Court may grant special leave to appeal in any matter except against an order of a court relating to the armed forces. The aggrieved party, that is, the party who is not satisfied with the decision or not satisfied with the sentence passed by the lower courts, may apply for special leave in civil cases, in criminal cases, in income tax cases, and in cases which come up before tribunals. Now comes advisory or consultative jurisdiction. So if instead of advisory jurisdiction, consultative jurisdiction, this word or this type of question comes, don't get confused. What is meant by advisory jurisdiction? The President may obtain the opinion of the Supreme Court on a question of law or fact which is of public importance. Questions may be specific and not general or vague. What is advisory jurisdiction? That means the President wants advice or opinion where from the Supreme Court regarding a question of law which is of public importance. The question will be specific, to the point, pinpointed, and not general or vague. It should not be going here and there. It should be beating around the bush. That type of question is not allowed. It should be a specific question. The Supreme Court may report its opinion after such hearing as it thinks fit. 2 points need to be made out of this. First, the Supreme Court is not bound to express any opinion on the question submitted to it. The Supreme Court is not bound to answer. If the Supreme Court deems fit, the Supreme Court can answer. And secondly, the advisory opinion of the Supreme Court is not binding on the President or on any court because it is not a judicial decision. It is whatever the decision or the advice the Supreme Court gives, it's an advisory jurisdiction. It is not a judicial decision. It's not a legal decision. So, the President or any other court is not bound to listen whatever the Supreme Court has said. It's an advice given by the Supreme Court because the advice was asked by the President or the advice was asked by any other lower courts. Okay. Now comes judicial review. What is judicial review? Now, judicial review may be defined as the power of the Supreme Court to examine the laws passed by the legislature and the orders issued by the executive officials to find whether or not they are permitted by the Constitution. Any law which is passed by the legislature or any order which is issued by the executive officials, the Supreme Court has the power to examine it just to see that the nuances or the different points of the law, whether they are permitted by the Constitution or not, whether it's an unconstitutional law or not. If the court finds that the law or an order of the executive does something that is forbidden by the Constitution, it declares null and void. So, if the law which has been passed or an order which has been passed goes against the Constitution, the Supreme Court declares the law non-functional, that is null and void. The final say as to what the Constitution means rests to the Supreme Court. That is why the Supreme Court is known as the guardian and the final interpreter of the Constitution. So, whatever regarding the Constitution, the final say will be rests on the Supreme Court. So, it is known as the guardian of the an interpreter of the Constitution. Okay. So, if a question comes, you can explain why the Supreme Court is known as the guardian and the final interpreter of the Constitution. Now, what is the scope of the judicial review? The scope of judicial review. The Supreme Court exercises judicial review in following ways. What are the ways? When there is a dispute between the union government, that means the central government and the state, and a state, or between states, the Supreme Court can decide it. Okay. Number 2, the Supreme Court has the power to review all national and state laws and executive orders and declare them null and void if they go against the provisions of the Constitution. Number 3, the Supreme Court is the guardian of the fundamental rights. It is empowered to issue various writs to enforce the fundamental rights. Okay. Now, the Supreme Court has made effective use of the power of judicial review in various cases. What are the limitations? The Constitution's First Amendment Act added a new schedule to the Constitution and provided that the law placed under this schedule would not be called in question in any court on any ground. Accordingly, many land reform laws have been placed under this schedule, so it remains beyond the scope of any legal debate. What is the significance of judicial review? There is no doubt that the legislature possesses the highest position in a democracy. But the power of judicial review has the utility because of 3 reasons. First, ours is a written constitution. An article of the Constitution or a law may be ambiguously worded, very confusingly worded. So naturally, the question of interpretation of the Constitution is bound to arise at times. Secondly, the Constitution has provided limited powers to the center and the state. If the union government or the state government goes beyond their limits, it should be checked. Only Supreme Court can settle that dispute. And if the union government and the state government starts functioning as a federal government, like a federal lord, a federal government, so the Supreme Court can settle the dispute between the government of India or any other state. Third, the legislature does not possess the ability and impartiality which are needed to explain what a law means. You have to be very impartial. You cannot take sides while you are doing any legal procedure. It does not have the ability to take quick decisions also. So this function can be best performed by a judicial body alone, because judicial body is supposed to be impartial. This function can be best performed by a judicial body alone. But the Parliament can amend the Constitution or override the effect of a judicial decision. The Parliament has the power to override the effect of a judicial decision. Now, enforcement of fundamental rights and writs. A writ is a legal instrument to enforce obedience of orders of a court. It's a legal instrument where some orders are given from the court which you are bound to listen. The Supreme Court is empowered by the Constitution along with the High Courts to issue certain writs or orders. So this Constitution empowers the Supreme Court and the High Court to issue certain writs or order. First is, you have to remember all these because they are very important from the Icse point of view. Writ of habeas corpus. Habeas corpus in Latin means you may have the body. It provides a remedy for a person who has been unlawfully held in a prison or in a police custody. If a person is unlawfully taken to police custody, this habeas corpus comes to action. The writ can also be issued where a person has been detained by a private individual. The Supreme Court and the High Courts command the detaining authority to bring the prisoner to court and explain why he has been held. In the case of insufficient, if the case is insufficient, the prisoner is at once unconditionally released. Then comes mandamus. The Latin term mandamus means we command. The purpose of the writ is to compel an inferior court, lower court, or an individual to perform the duty. The duty must be imposed by constitution or by some law. Mandamus will not lie against a private individual or organization unless they are entrusted with a public duty. Any government organization or any inferior court, if they are not performing their duty properly, mandamus can be used or applied. But mandamus cannot lie against a private individual or a private organization unless the organization is entrusted to do some public duty. Prohibition. Writ of prohibition is issued to prevent an inferior, means lower court, from exercising powers which is not legally vested. That means if the lower court exercises or uses power which is not legally given within the periphery, if it goes beyond the periphery in exercising the legal power, the Supreme Court and the High Court direct the inferior court to keep within the limits of their jurisdiction. Certiorari. The term certiorari means to be informed of what is going on. By this particular writ, the lower court is asked to hand over the record of a particular case to the higher court. Now, the writ of prohibition and the writ of certiorari, what does it aim? Both of these two writs aim at restraining the inferior courts from exceeding their jurisdiction, going beyond their limit. The difference between the two is that they are issued at different stages of the proceedings. When an inferior court is hearing a matter over which it has no jurisdiction, the superior court shall issue writ of prohibition. On the other hand, if the court hears the case and gives a decision, the superior court shall issue writ of certiorari. The writ of prohibition is preventive, where the writ of certiorari is remedial. Very, very important. Last writ is writ of quo warranto. Quo warranto, the writ is directed against a person who has wrongfully usurped an office. The office must be a public office. Usurped means taken. Public office means government office or an office of public nature. The treasurer of a society, for instance, is not a public office. The writ calls upon the person to show under what authority he holds the office. If the court decides the person concerned is holding the office illegally, it may declare the office to be vacant. It can declare the person to vacate the office. So with this we come to the end of the revision of the Supreme Court. Thank you very much.